Welcome back to Juvenile Justice Policy, CRJU 303A. Today we will be discussing key figures in juvenile court proceedings. By the end of this chapter, you should be able to explain the role of the prosecutor and defense counsel, understand the relationship between the prosecutor and the defense counsel, and describe the responsibilities of the juvenile court judge and probation officers. You should also be able to discuss the roles of children and family services, victims advocates, and court-appointed special advocates in juvenile court proceedings. Additionally, you should be able to explain how victim advocates function within the adult court system and understand the types of training provided to juvenile court personnel. The prosecutor ultimately decides whether a juvenile case will proceed in juvenile court, regardless of who made the initial referral. This means the prosecutor holds significant discretionary power, because even when police or other authorities initiate contact with the system, the prosecutor can still decline to file charges and effectively close the gate to further action. Sometimes this discretion is exercised for legitimate reasons, such as insufficient evidence, lack of probable cause, or due process issues that make prosecution impossible. However, history also shows that prosecutors have occasionally declined cases for political, personal, or strategic reasons, such as protecting well-connected families or prioritizing cases that may generate favorable publicity. Because of this, prosecutors must remain mindful of ethical obligations and professional expectations, as their decisions shape how cases move through the juvenile justice system. Over time, legislative reforms have reduced some of the discretion prosecutors traditionally held, especially regarding decisions to transfer juveniles to adult court. Many states now mandate or presume transfer under certain conditions. For example, Illinois law requires prosecutors to request adult court transfer for youths aged 15 or older who commit a forcible felony and have a relevant delinquency history or gang involvement. These statutory controls are intended to prevent abuse of power, respond to public concerns about juvenile violence, and create clearer, more consistent guidelines for transfer decisions. Even with such constraints, prosecutors continue to be central figures in juvenile court practice. Historically, juvenile courts did not rely heavily on prosecutors because early juvenile courts were designed to be non-adversarial and focused on the child's welfare. Landmark cases, such as Kent, Galt, and Winship, transformed this model by emphasizing due process and the adversarial structure of modern juvenile proceedings. As a result, prosecutors became essential players, representing the state's interests and navigating a more formal legal process. Today, prosecutors determine whether cases reach court, influence waiver decisions, shape the petition, and often drive the recommended disposition. Judges rarely impose outcomes that exceed the prosecutor's recommendation. Because youthful offenders are now guaranteed certain constitutional protections and juvenile crime receives intense public attention, prosecutors' influence is likely to remain strong. Some prosecutors also use unofficial probation, in which they agree not to formally pursue charges if the youth complies with behavioral conditions similar to those imposed after adjudication. While this approach may reduce caseloads and spare some youth from formal adjudication, it raises concerns about fairness because it can function as punishment without trial and may not always be voluntary. It can also disadvantage abused or neglected juveniles who remain in unsafe environments because their cases are not formally adjudicated. Modern juvenile prosecutors handle far more than gatekeeping. They must understand violent juvenile crime, victims' rights legislation, transfer laws, and expanded juvenile court jurisdiction. They also serve as negotiators and advisors during disposition discussions, recognizing that not all juvenile offenders or offenses are the same. During plea bargaining, prosecutors may adjust charges based on aggravating or mitigating factors observed in individual cases. Regardless of case specifics, the prosecutor participates in every proceeding at every stage when the state has an interest. The overall process for determining whether to formally charge a juvenile is outlined in the book under Figure 9.1. The Institute of Justice Administration and the American Bar Association emphasize that juveniles must have legal representation in all proceedings related to delinquency or supervision, including matters involving competency, transfer, post-disposition issues, probation, revocation, classification, institutional transfers, and disciplinary or administrative actions that could affect their custody, treatment, or legal status. Because juvenile court proceedings have become fully adversarial, the role of defense counsel has become increasingly essential. Today, most jurisdictions require that every juvenile named in a petition be represented by an attorney, and some states, like Illinois, do not allow a case to proceed unless counsel is present. In many cases, the juvenile's parents also have representation, and courts may appoint a guardian ad litem to serve as an impartial advocate for the child's best interest in abuse, neglect, and dependency cases. Defense counsel in juvenile court generally fall into two separate categories: private attorneys and court-appointed counsel, including public defenders. Although some juveniles retain private attorneys, most are represented by court-appointed counsel whose services are funded by the state or county. Public defenders often enter the field with an interest in criminal law, yet many face low salaries, short job tenures, and limited agency resources. As a result, public defender offices frequently struggle with an inadequate funding, heavy caseloads, limited investigative support, and a reputation, often unfairly, of providing lower quality representation. These challenges contribute to high workloads, limited client contact, and frequent reliance on plea negotiations, which can negatively affect the attorney-client relationship and the public's perception of public defenders. Underfunding and high caseloads also lead to concerns about the quality of advocacy. Some public defenders may miss opportunities to challenge legal errors, pursue appeals, or use all available strategies to defend their clients. Although many defenders are dedicated and effective advocates, research suggests that juveniles with private attorneys often achieve more favorable outcomes than those represented by public defenders. The criticisms of public defender performance are largely rooted in structural problems rather than individual failings, and many organizations, including the National Juvenile Defender Center, have proposed reforms. These reforms include expanding clinical and experiential learning opportunities in law schools, engaging institutions serving minority populations, creating juvenile defense committees within bar associations, and developing legal incubator programs to support new juvenile defenders. Despite differences in resources or employment status, all defense counsel share the same core responsibilities: protecting their clients' rights at every stage of the juvenile justice process, ensuring the client is fully and fairly represented, and presenting the case in the most favorable light possible. Defense attorneys must challenge the prosecution when necessary and ensure that procedural and constitutional protections are upheld. However, because public defender offices remain understaffed and private counsel is often financially inaccessible, the quality of representation is uneven. Scholars and practitioners emphasize that improvements to defense representation are needed throughout the juvenile court system to ensure fair and effective advocacy for all youth. Specifically, consider Indiana's new model. Indiana no longer hires solely public defenders. Public defenders in Indiana typically hold two separate jobs, both working as private counsel and working as a public defender. This has helped to even the playing field in states like Indiana. In theory, adversarial proceedings occur when the defense counsel, acting as the champion of the defendant, and the prosecutor, acting as the champion of the state, engage in open courtroom battle in pursuit of truth and justice. In practice, however, the process often looks very different due to the practical constraints of time and financial resources for both the state and the defendant. The idealized adversarial model is closest to reality in high-profile cases where a prominent, well-resourced private defense attorney can face off against the state, as seen in O.J. Simpson's trial in the 1990s. In such situations, the balance of power is nearly even. By contrast, public defenders, who are often paid less, carry heavier caseloads, and have more limited investigative resources, frequently find themselves at a disadvantage. For those reasons, both prosecutors and defense counsel often prefer negotiation to litigation, as court trials are costly in terms of both time and money for both the defense and the state. The vast majority of adult criminal cases and a significant number of delinquency and child welfare cases are resolved through plea bargaining. Scholars have suggested that justice in the United States often results not from pure adversarial combat, but from a cooperative network of routine interactions among prosecutors, defense counsel, defendants, and sometimes judges. Plea bargaining is rooted in compromise, of course. Prosecutors seek a guilty plea, if not to the original charge, then to a lesser offense, while defense counsel aims for the best possible outcome for their client, ranging from dismissal to a reduced charge. The terms of the bargain depend on factors such as the strength of the prosecutor's evidence and the seriousness of the offense. Typically, both sides negotiate what they regard as a fair compromise before the defendant even appears in the courtroom, effectively bypassing the entire adversarial process. A hypothetical example illustrates this dynamic. A juvenile caught burglarizing a home faces the possibility of being charged as an adult. After negotiations, the prosecutor agrees to keep the case in juvenile court in exchange for an uncontested allegation of delinquency, while the defense secures a recommendation for a shorter period of detention. The formal court appearance becomes little more than a procedural confirmation of the negotiated outcome. The benefits of plea bargaining are clear. Prosecutors secure convictions, defense counsel obtain reduced charges or penalties, and courts conserve their limited resources. Juveniles may benefit as well, avoiding adult convictions and harsher sanctions. However, the dangers of plea bargaining should not be ignored. Jurisdictional transfers might have been denied, defendants might have been acquitted, and private negotiations can compromise constitutional protections such as the right to confront witnesses. Additionally, plea bargaining often reduces the judge's role to that of a figurehead, raising concerns about due process and the victim's sense of justice. My own experience as a prosecutor reflects this nuanced balance between adversarial roles and cooperative realities. I worked regularly with defense counsel to meet our respective goals, even though those goals differed. My responsibility was to reach a resolution that was fair to the defendant or delinquent, the victim, the state, and any other affected individuals, such as those who were owed restitution. At the time, I had to remain mindful of the overarching aims of the justice system on the whole. Defense attorneys, while not opponents in a personal sense, approach cases with their own priorities, securing release, challenging the state's evidence, and minimizing the severity of the outcome. Despite these differences, we often collaborated to reach resolutions acceptable to both sides. When my evidence was less than ideal, I reduced charges or adjusted sentencing recommendations, sometimes outright dismissing cases. When the defense recognized that the case against their client was strong, they shifted their advocacy towards rehabilitative rather than punitive options. Even in trials, the term adversary, while technically correct, rarely captured the true nature of the interactions. In most legal communities, attorneys conduct themselves with professionalism, decorum, and mutual respect. This atmosphere transforms the courtroom from an arena of battle into a venue where known facts are carefully evaluated by a judge or jury. My experiences underscored that the justice process is rarely about defeating an opponent. Instead, it is about ensuring a fair and reasoned resolution within the framework of the law. In theory, the juvenile court judge is the central and most powerful figure in the juvenile justice system. But in practice, the judge operates within a broader courtroom work group of attorneys, probation officers, and other professionals who develop shared norms and emphasize efficient case processing. Juvenile courts differ from adult courts because judges frequently rely on the assessments of non-lawyers, especially probation officers and mental health professionals, when evaluating the youth's background, family environment, and rehabilitation needs. Ultimately, juvenile court judges decide whether a youth will be adjudicated delinquent, dependent, abused, or neglected, and because jury trials are rare, the judge's findings are usually final unless reversed on appeal. Judges also determine the disposition, deciding both legal and factual issues and exercising significant discretion in shaping a child's immediate future. Despite this broad authority, juvenile court assignments are not always viewed as prestigious, and many judges hope to rotate out of the juvenile division as part of career advancement. Many states appoint referees or commissioners to conduct hearings and submit recommendations that require judicial approval before they have legal effect. Within statutory limits, juvenile judges rule on pretrial motions involving arrest, search and seizure, and interrogation, determine whether the youth should remain in detention, and approve or reject plea bargains or informal adjustments. They preside over bench adjudications, oversee the presentation of evidence, rule on procedural issues, guide witness questioning, make treatment decisions, and conduct waiver hearings or appeals where authorized. Juvenile court judges can be understood along a continuum. On one end is the parent figure judge, who views the role as one focused on the total well-being of the youth. These judges may overlook some formalities of due process in order to act as a supportive, but sometimes disciplinary, parental authority. They often seek expressions of remorse from juveniles or their families and may forgive the behavior once remorse is shown, shifting attention toward preventing future misconduct. When remorse is absent, these judges may respond more harshly and may even place less emphasis on the factual strength of the case. Parent figure judges frequently continue cases under supervision rather than adjudicating them, assuming that a pending threat of adjudication will motivate good behavior. However, when used excessively, continuances can amount to punishment without trial and may contribute to a revolving door effect in which youth return repeatedly to court without resolution. At the opposite end of the continuum is the lawgiver judge, who prioritizes strict adherence to procedural safeguards and evidentiary requirements. These judges focus more on the legal sufficiency of the case than on the personal circumstances of the juvenile. They dismiss cases that cannot be proven beyond a reasonable doubt or by the required standard in abuse and neglect matters, and they refrain from prescribing treatment unless the legal threshold for adjudication is met. Their dispositions rely heavily on statutory guidelines rather than individualized considerations. Most juvenile court judges fall somewhere in between, reflecting ongoing debate about the proper purpose of juvenile court. These judges often seek to protect due process rights while also acting in the best interests of youth and the broader community. They make efforts to ensure access to counsel, strive for objective decision-making during adjudication, and consider each child's needs when determining disposition. As one description of abuse and neglect proceedings notes, the judge, lacking jury support, must base decisions on investigator reports, courtroom testimony, personal experience, and a practical sense of what is best for everyone involved. Probation is the oldest and most widely used disposition in the United States and allows juveniles to remain in the community under court-imposed conditions while supervised by a juvenile probation officer. Probation can serve as a front-end option for first-time low-risk offenders or a back-end option to institutional confinement for more serious offenders, providing opportunities for youth to remain with their families or in foster care while meeting behavioral expectations. Juvenile probation officers play a central role at all stages of the juvenile justice system. They may arrange preliminary conferences between parties to achieve out-of-court resolutions in delinquency, abuse, or neglect cases. After adjudication, probation officers typically conduct social background investigations to help judges make informed dispositional decisions. They also supervise juveniles on probation, oversee parents who may be involved in neglect or abuse cases, and can request probation revocations if conditions are violated. In some jurisdictions, probation officers work alongside truancy officers to monitor school attendance and support youth engagement and education. Chief probation officers manage staff assignments and supervise subordinates while serving as liaisons between judges, department heads, and community agencies. Their effectiveness in these roles directly impacts the ability of probation officers to serve juveniles and protect community interests. The role of juvenile probation officer is often ambiguous. They must balance authority and discipline with efforts to help juveniles avoid court, recommend dispositions based on risk and needs assessments, protect youth from abusive environments, and assist parents in navigating challenges. Probation officers are increasingly expected to facilitate pro-social behavior, requiring them to foster trust and open communication with juveniles and their families while avoiding extremes of authoritarianism or overfamiliarity. Probation officers traditionally broker services to aid rehabilitation, including mental health counseling, substance abuse programs, academic and vocational training, mentoring programs, and foster care support. In some jurisdictions, probation officers also act as change agents, using therapeutic strategies, cognitive behavioral interventions, and structured programming to influence juvenile behavior and thought patterns. These approaches require significant time and one-on-one engagement, which can be difficult given large caseloads. Juvenile probation officers may identify primarily as law enforcement officers, advocates, or social workers, but the most effective officers adapt their approach according to their circumstances. Balancing these multiple roles can lead to role identity confusion, which is a primary cause of burnout among probation officers who supervise youth. Supervision is often the most challenging aspect of the job, particularly with high caseloads that may range from 50 to over 300 juveniles at any given time. Probation officers must navigate limited direct contact, stigma concerns, and parents attempting to use their authority to enforce compliance. To address these challenges, some officers schedule meetings flexibly and meet probationers in safe, controlled settings such as schools. Probation officers also contend with safety concerns, insufficient resources, and rising caseloads. Innovative approaches such as intensive supervision programs, school-based monitoring, and technology like electronic monitoring and GPS tracking help officers manage supervision while enhancing compliance and accountability. These tools can track juvenile movements, warn potential victims, and monitor adherence to court-imposed restrictions. In summary, juvenile probation officers serve as key facilitators, supervisors, and change agents within the juvenile justice system, working to balance accountability, rehabilitation, and community safety while navigating complex and often competing role expectations. Personnel from Departments of Children and Family Services, often referred to as CPS or Child Protective Agencies, do not directly work for the juvenile courts but play critical roles in investigating abuse and neglect cases, presenting evidence, and making dispositional recommendations. When law enforcement officers suspect abuse or neglect, they are typically required to report the case to Children and Family Services, which maintains a central register of such reports. Upon receiving a referral, child protective personnel initiate an investigation which in emergency cases should be conducted immediately and in other cases within a specified time frame, usually between 24 and 72 hours. These investigations generally involve interviews with the alleged victim and offender and an evaluation of environmental risk factors, with children sometimes being removed from the home to ensure their safety. If allegations are substantiated, caseworkers assist children during court proceedings and develop plans for services or treatment for both the child and the family. In cases of institutional abuse or neglect, child protective personnel monitor the institutions if they remain operational. Increasingly, children's services operate within collaborative networks or coalitions, bringing together state, local, and nonprofit agencies to address interconnected social issues such as substance abuse, domestic violence, sexual assault, mental health, and juvenile delinquency. These coalitions are intended to provide more comprehensive support by coordinating service across agencies. An example is the Children's Coalition of Northeast Louisiana, which collaborates with juvenile court judges and the local district attorney, probation officers, and youth-oriented social services to deliver programs and support for abused children and youth who engage in delinquent behavior. Personnel in these roles often act as liaisons between the courts and the community, ensuring that services are tailored to the needs of both the child and the family, while maintaining the child's safety and well-being. By coordinating investigations, service, delivery, and court participation, Children and Family Services personnel are essential to the effective functioning of the juvenile justice system. Just as in adult crime, juvenile offenses often have victims who are harmed during the commission of the offense. Historically, these victims have not always had representation or support during court proceedings. While adult courts have gradually increased victim advocacy services, juvenile courts have been slower to do so. Victim advocates were initially developed to support crime victims in adult courts, but their services are increasingly expanding to the juvenile justice system. Victim advocates may be employed by district attorney offices or by nonprofit organizations focused on issues such as rape or domestic violence. Their role typically includes explaining court procedures to victims, providing encouragement and support throughout the legal process, and offering information about resources such as counseling or restitution for victims and their families. Challenges to affect victim advocacy in juvenile court arise from the offender-centered focus of the system and the structural barriers to meaningful victim participation. The court traditionally emphasizes interventions that address the needs of the juvenile offender and the community, often neglecting the victim's perspective. Policies, administrative procedures, courtroom culture, and the judicial style, whether a parent figure or lawgiver approach, can all limit the victim's involvement. In response, state legislatures have enacted statutes granting victims rights similar to those in adult courts. Juvenile court acts, policies, and administrative rules have been modified to better integrate victims into the court process. Additionally, restorative justice practices have been widely adopted, elevating the role of the victim in both court proceedings and offender dispositions, and promoting outcomes that consider the harm done to the victim as central to justice. Victim advocacy in juvenile court has long existed, though historically it was limited primarily to cases involving abuse and neglect. A key organization providing this service is the Court-Appointed Special Advocates, or CASA. CASA volunteers are trained citizens appointed by the court to advocate for children who are victims of abuse and neglect, offering recommendations in the child's best interest. These volunteers are typically ordinary citizens without formal legal training, but they are deeply committed to ensuring the welfare of the children they serve. CASA volunteers work closely with departments of children and family services and are generally assigned to one case at a time by a juvenile court judge. Their responsibilities include researching the child's background, reviewing court documents, and interviewing all parties involved in the case, including the child. After gathering and evaluating information, CASA volunteers prepare a written report for the court with recommendations based on what they believe is in the best interest of the child. Judges may consider these reports when making decisions about disposition. Once a case is decided, CASA volunteers often continue monitoring the child and family to ensure that the court-ordered services and supports are delivered effectively. While CASA programs are rare in delinquency cases, they may be assigned if the juvenile has a significant history of abuse or neglect that could be influencing delinquent behavior. Overall, CASA volunteers provide a vital, independent perspective focused solely on the well-being of the child. For the juvenile justice system to achieve its goals, it must be staffed by well-trained and competent practitioners. Unfortunately, a number of factors have historically limited success in this area. Prosecutors and defense attorneys handling juvenile cases often have little incentive to invest significant time or resources. Few defense attorneys gain national recognition from their work in juvenile court, and few prosecutors are rewarded electorally for juvenile case outcomes. In many jurisdictions, juvenile court is perceived as less serious than other courts, reducing the motivation to specialize in juvenile law. Consequently, inexperienced prosecutors and defense attorneys may handle cases, resulting in poorly prepared proceedings. Some prosecutors lack familiarity with their jurisdiction's juvenile code, while some defense attorneys fail to present witnesses, challenge hearsay evidence, or object to procedural violations that could lead to dismissal of petitions. Although legal representation for both sides has increased, the quality often remains inconsistent. Many juvenile judges serve part-time or rotate from other court divisions. While many judges have the best interests of juveniles in mind, some demonstrate the same unfamiliarity with juvenile codes as attorneys, and a few even disregard juvenile law altogether. Knowledge of juvenile codes and proper training are essential to uphold constitutional protections and due process in juvenile cases. Treating juvenile court as less than a real court has made it unattractive to lawyers and judges, though evidence suggests that a more competent and informed corps of juvenile court practitioners is emerging. Recognition and rewards can encourage the growth of such a corps. Probation and social service positions generally require at least a bachelor's degree, with many practitioners holding master's degrees. Juvenile probation officers, for example, are typically college educated and have a reported median annual wage of $54,209 in the United States. Many employers are also requiring candidates to pass oral, written, and psychological examinations. The standards for the administration of juvenile justice, published by the IJA and ABA in 1980, emphasize the need for perseverance and in-service training for all juvenile court personnel. Family court judges should receive pre-service training on the law and procedures governing juvenile court, the causes of delinquency and family conflict, and an understanding of agencies responsible for intake and protective services. In-service programs ensure that judges remain current on changes in the law, policy, and programs. Similar recommendations apply to prosecutors, public defenders, and other court personnel. Today, there is a widespread access to training for juvenile justice personnel. The National Council of Juvenile and Family Court Judges provides ongoing programs, and its Juvenile and Family Court Journal keeps practitioners informed of the latest developments. Many states also require annual training for judges and probation officers to maintain competence in juvenile justice practices. Key figures in juvenile court include attorneys for the state and defendant, the judge, probation officers, and children and family services personnel. Competent, well-trained professionals are essential to ensure juveniles receive fair treatment and effective interventions, and judges who balance the parent figure and lawgiver roles are particularly valuable. Probation officers and social service personnel play critical roles in supervising juveniles, coordinating services, and supporting rehabilitation, complementing the work of attorneys and judges. While the quality of juvenile court personnel is improving, continued emphasis on training, professionalism, and expertise is necessary to achieve the goals of the juvenile justice system. I'll see you in Chapter 10.